the Honorable Presiding Justice and Associate Justice of the Court of Appeal for the State of California and for the Third Appellate District. Hear he, hear he, hear he. Court of Appeal is now in session.
Good morning. Go ahead and take your seats. Thank you. This is the matter of Richard Brown versus the Department of Motor Vehicles, case C102554. Are you Mr. Brown? Thank you. Mr. Brown is present, representing himself at the hearing today. Would counsel for the respondent please state your appearance? All right. Mr. Brown, if you'd like to, if you could stand at the podium there to give us your argument. You do have 15 minutes to deliver your argument, but if you would like to reserve some time to respond to Ms. Chen's argument, you can do that. You have a clock in front of you that will begin counting down, but if you would like me to remind you when you get to a certain amount of time left, I can do that. It's up to you.
Yes, ma'am. Your Honor, I would like to save 4 minutes for my rebuttal.
Save 4?
Yes, ma'am.
Would you like me to remind you when you get there?
Absolutely.
Thank you. Go right ahead.
All right. May it please the court, good morning, Your Honors. My name is Richard Lewis Brown. I have over 18 years of a perfect California driving record, seeking justice in what can only be described as a weaponization of the administrative complaint process. No family member, friend, neighbor, co-worker, or medical provider or even a court has ever contacted the DMV for any reason about my driving ability. Then the question is, then why and who would know legally how to use the system to intentionally and repeatedly cause me harm and fear for my safety? What about future DMV complaints that can be filed against me by this same anonymous person? I ask this court to historically step into my shoes and establish precedent by revealing the identity of my accuser and his repeated willful malicious persecution that has caused me profound harm, and to prevent future abuse of a system designed to protect public safety. No governmental agency may deprive a citizen of a protected liberty based on a non-bona fide, anonymous complaint without affording meaningful due process that includes identifying the complainant. In Mackey versus Mountrum, the U.S. Supreme Court held driving is a protected liberty interest essential in the pursuit of livelihood. So why are we here today? The central question, does the public interest in maintaining the secrecy of DMV complainants outweigh my constitutional right to confront my accuser when that accuser is deliberately engaged in a repeated campaign of harassment, stalking, and willful, malicious, repeated persecution?
Mr. Brown, let me ask you a question. I think I understand your point. But the Department of Motor Vehicles afforded you a hearing, not one, 2 hearings, the second of which you prevailed at. Why isn't that sufficient due process? In other words, it doesn't appear to me that they ultimately relied on the referral that they received. They conducted their own hearing.
Your Honor, that question is, if I have a perfect driving record, and no one has ever seen me drive in a reckless manner in the state of California for over 18 years, then why would DMV, off some type of anonymous complaint, make me be medically cleared? And then I'm cleared on that first time, and then that same person, within 15 months, does it again. So in June of 24, an anonymous complaint was made against me. Then in October of 25, it's made against me again by the same person. That's my answer.
And I guess my question was, why isn't the hearing that you received sufficient due process?
Because I should have never had to have gone through that hearing when the person made an anonymous complaint based off of fraud, based off it had no merit, it was malicious. So if a person has a perfect driving record for over 18 years in the state of California, and his family, his work, his neighbors, no one has ever seen this person drive in a reckless manner, then why would DMV put me through that situation and waste tax?
Brown, you know, people can have a perfectly good driving record, and then they get older, or they can have a medical issue or something that changes the circumstances, even though they've had a very fine driving record beforehand. So I understand that you had a good driving record, and you prevailed because they they made a mistake the first time, but the second time they said you didn't have to have your license revoked. There was no basis on it. But you had the doctor's notice that came in, and remember, said, I think you should have a driving test. Now, that was on the doctor's certificate that you submitted.
Well, Your Honor, there was confusion on that doctor's note because one part said that I shouldn't be tested, that I was fine to drive and I was alerted, and then she inadvertently marked the wrong box.
Well, that's not the department's fault if the doctor inadvertently checked the box. I mean,
Right.
if the doctor had said everything was okay, they may have stopped there. You don't know, but because the doctor checked the box saying you should have a test.
Right. So when they set that aside, saying that I should never been tested to begin with, that was in the second hearing officer's notes, that I should never been tested to begin with. There was no reason to be tested.
Except for the doctor saying so.
The doctor said one part, I should be tested, then another part, the doctor said I was fully alert, there was nothing wrong with me. But I'm not trying to dispute your authority, sir.
Thank you. I think we understand the argument. Thank you for the clarification.
Okay. So, Your Honors, the evidence overwhelmingly points to a highly intelligent person with possible military and or civilian educated legal expertise. I'm asking this court, would the court allow secrecy to be perverted into a sword of retaliation while this person of moral turpitude hides behind procedural protections never intended for such abuse? Here's the timeline that I informed the public what I was going through. December 2022, I filed a lawsuit against my union, Local 1000, and 42 individual defendants. August of 2023 through December 2024, I filed 8 appeals. May 2024, I filed a defamation lawsuit. June 2024, exactly 1 month later, the first of 2 anonymous, secret DMV complaints is filed against me citing mental health, that I may not be safe to drive. September 2024, after providing medical documentation confirming my fitness to drive, DMV reversed itself and issued its first order of set aside, effectively conceding the complaint had no merit. The hearing officer's own report confirms the medical report has no diagnosis of any P&M condition that would have required a person to be tested by the department. This reversal proves what I've argued all along. The complaint was false, malicious, and filed in bad faith by someone who weaponized the DMV process that has nothing to do with my current fitness to drive. Now, I am asking this court to be the first California appellate court to order disclosure of an anonymous DMV complainant's identity by combining the existing California Supreme Court cases Perkey, Sands, and White, while also applying federal constitutional principles from the cases Green and Wilner. This is a constitutional dimension of due process and the right to confront a person's accuser. I acknowledge to you, the Sixth Amendment guarantees the right to confront one's accuser in criminal proceedings. While this is only an administrative matter, the due process protections of the Sixth and 14th Amendments should still apply, just without the guarantee. However, California Constitution, Article 1, Section 7 guarantees due process requiring fair procedures when the government acts against a person. Even exceptions still allow the accuser to be identified in a secure manner. When an anonymous complaint can result in the deprivation of a fundamental liberty interest, the right to drive, which affects employment, healthcare access, and basic life functions, procedural due process demands that I be permitted to confront and cross-examine my accuser, particularly when the complaint is completely false, filed in bad faith, and has a retaliatory motive, which was proven with the second one filed within 15 months of the first one by the same person. The balancing test. California courts have recognized that secrecy in administrative complaints is not absolute. Courts must balance the complainant's privacy interests against the respondent's right to defend against false accusations. Evidence Code 1041 requires balancing tests by statute. In Sands versus Morongo Unified School District, California Supreme Court held the right to gather evidence essential to the defense of a lawsuit may override their right to privacy. In Perkey versus DMV, the California Supreme Court also held confidentiality does not extend to protecting false or malicious reports, which directly limits Vehicle Code Section 1808.5 confidentiality protections. In White versus Davis, the California Supreme Court also held statutory confidentiality cannot violate constitutional rights. Where conflict, Constitution prevails. So the Vehicle Code 1808.5 cannot override the Constitution. The Charlottesville case in 2018, right here in California, the federal court ordered disclosure of an anonymous user's identity after applying a balancing test, finding that the need for the information outweighed the First Amendment privacy interests. Green versus McElroy, the U.S. Supreme Court held, process requires evidence to be disclosed so accused can show anonymous accusation is untrue. Also, in the Wilner versus Committee, the U.S. Supreme Court held due process requires 1, notice, 2, confrontation of witnesses, and 3, opportunity to defend. Here, the balance weighs decisively in my favor. The complaint is false. The complainant engaged in retaliation. This person is seeking to undermine my credibility in my other lawsuits. The professional harm to me is ongoing and severe. My license, employment, and reputation are at stake. This was not a good faith safety complaint, but a willful, malicious, repeated attack to put my life in fear. DMV's responsibility. My opinion, Your Honors, DMV has failed to investigate the source and motive behind these complaints. They have accepted at face value complaints based on a baseless accusation, ignored the timing and pattern suggesting retaliation, and refused to investigate whether the complainant had a motive against me. DMV has become complicit in a person's harassment by providing him a shield of secrecy while he wages a campaign of retaliation against me. What precedent does this set? If disgruntled defendants in civil litigation can weaponize anonymous administrative complaints to retaliate against plaintiffs, we create a perverse incentive structure where plaintiffs, such as myself, are discouraged from filing legitimate lawsuits. Defendants can repeatedly harass plaintiffs with impunity. Administrative agencies become tools of abuse rather than public protection. I am a reasonable person, and I fear for my safety. And I respectfully ask this court, please order the DMV to disclose the identity of the complainant for this June 2024 complaint and grant me leave to pursue sanctions against this person for abuse of process. Please establish clear historical precedent that complainants' identity protections in administrative cases doesn't provide absolute protection and cannot shield willful, malicious, retaliatory, repeated complaints that put a person's life in danger. Thank you very much.
Thank you, Mr. Wright.
Good morning, Your Honors. Deputy Attorney General Joanne Chen for Respondent DMV.
Ma'am, could you put the microphone closer to your mouth, please? Thank
My
you.
apologies, is that working?
Thank you.
May it please the Court. This case concerns the trial court's denial of appellant's September 17th, 2024 petition seeking for the identity of the individual who reported him for reexamination to the DMV. The trial court's judgment of denial should be affirmed for 2 reasons. First, the trial court was correct to deny the petition based off its weighing of the evidence under Evidence Code Section 1040. And second, appellant received all due process due to him in those 2 DMV hearings. As to the first, the trial court exercised its use of discretion correctly in applying the balancing of interest test under Evidence Code Section 1040 to find that the identity of the reporter was protected. Appellant argued that under that balancing test, his interest in disclosure was that he intended to bring a legal claim against that person for false and malicious reporting. But in support of his claim of false and malicious reporting, he did not offer evidence beyond a mere speculation. The record reflects that appellant at that point had only been reported on this sole occasion in June 2024. Moreover, I add that the identity of this reporter is protected under the litigation privilege. Civil Code Section 47 sub B disallows appellant from claiming against this reporter.
Why does the department have an anonymous procedure?
Well, I would to that point, Your Honor, I do want to clarify. The complainant is not anonymous to the DMV. That person's anonymous to the subject driver, whomever is being reported upon. but the DMV does keep a record of who is submitting the report on that person and keeps a record of those reports.
So if somebody did it more than once on the same person, would the DMV take that into account and do something?
Absolutely. If the DMV sees that there is a basis where the substance of these reports, there's no factual basis for to indicate that this is an unsafe driving behavior that is related to what that person may believe to be a medical condition, then yes, that driver safety hearing officer is tasked with referring that case to DMV's investigations unit. And if whatever results from that investigation happens to be, yes, there's some indication of this reporter submitting bad faith reports, yes, that would be referred to the local prosecutor's office.
Because the basic problem here is it's twofold. One is whether the person who gets reported gets due process in determining what happens to him. And here it seems like the process has various safety measures in it. And in this case, the first officer did it incorrectly, and then one day later, the second officer changed it, and the Mr. Brown came out without any change in his driving status. So there's that issue, and then the other issue is whether the department has to reveal that so that the person who's charged with the driving issue can go after him or do something. So I think that's the second issue. So there's two separate issues here.
Well, if I could address perhaps the second issue first, I do want to note that the report itself is not evidence to be used against the subject driver in that DMV hearing, and certainly here that was not the case.
So that has no weight at all. It just starts a process. Is that what you're saying?
It begins the process if upon receiving that report, the DMV finds in its review that, yes, there is sufficient basis to refer this driver to
I mean,
the
if
examination
the reporter says this person has suddenly become blind because of some illness, you would look at that and say, oh, then you move ahead. Is that how you do it, or how is it done?
Well, no, that would actually be the purpose for the medical examination report, and that's why DMV asks for the drivers to take that medical examination form, take it to their physician, who should have familiarity with that person, to complete those fields, and whatever's contained in that physician's report, that would be used as the basis in favor of DMV's action at the hearing, and that's what happened here. It was just, and I think that this point would actually address, I think, Your Honor, what you mentioned about the first issue, about the fact that, for here, specific to Mr. Brown's case, his physician's report indicated very ambivalent findings. On one hand, she indicated, yes, DMV should be referring Mr. Brown for a skills and written driver's test. But on the other hand, she failed to note that.
She didn't say he had anything wrong with him that she knew.
I think more accurately, she failed to document a related medical diagnoses that would support it. But she did note that he had various other conditions that were perhaps maybe not playing into the factor of unsafe driving. Like I believe he had high blood pressure and other conditions that, because this was her first visit with him, she was not able to complete. Hence why those fields were absent. And I think that went into the first hearing officer's consideration, perhaps his confusion, the fact that he had very ambivalent findings from this physician. But I did want to speak a little bit about, perhaps, Your Honor, your concern about whether there are safety mechanisms that the DMV has towards filtering out malicious reports.
Yeah, I think that's important because Mr. Brown appears to be saying that someone did this because of some dispute they had with him, and the system is not designed for people to be going after each other. They're designed to keep the roads safe, I assume. So the department has steps and processes that can, and if somebody files 10 of these, or multiple ones of any number?
Oh, certainly. So to add on to what I mentioned before in regards to DMV's screening process, so that screening process is done by the safety hearing officers. Those safety hearing officers, they're trained in administrative law, they're trained in rules of evidence, and they're trained to be impartial. And it is upon that person's review of whether there is a sufficient factual basis based off of this person's report to refer that the subject driver to the reexamination hearing process. That is just one. The other mechanism that I do want to note is the whole referral process from the safety hearing officer to the investigations unit. If that safety hearing officer finds, oh wait, this reporter in fact has submitted 10. There could be something here. I might have a malicious report on my hands. Certainly, that safety hearing officer has and is tasked with referring that case to the investigations unit to determine if in fact we do have someone reporting in bad faith.
But you're saying, I think you said that the essence of the complaint is not actually part of the record when the process starts, when they have an administrative hearing.
That's correct.
It goes only on evidence that developed at the hearing.
Oh, I'm sorry, Your Honor.
It only works on evidence that's produced at the hearing by somebody.
So the hearing only looks at evidence that is presented before it in terms of, well, perhaps I can be more specific. So the safety hearing officers in adjudicating Mr. Brown's case only looked at the evidence that was contained in his physician's report. Neither hearing officer relied on anything that was contained in
The complaint.
Correct.
That's the point I wanted to have you clarify.
Yeah, Ms. Chen, before you go on, a few minutes ago you mentioned, made reference to a litigation privilege, I think I heard you say. I'm not quite sure how, unless I misheard you, I'm not quite sure how the litigation privilege works into this.
Certainly. And I would point to, as support of how litigation privilege would apply here, this court's 2000 case, Wise v. Thrifty Payless. There, this court held that litigation privilege exists to protect individuals when they send in communications to agencies tasked with investigating wrongdoing, such as the DMV, in order to initiate the agency's official action, and that's exactly what happened here.
Okay, so in other words, the idea is that this process is tantamount to litigation, I take it as your point, and thus the matters that are testified to or otherwise referred to are privileged material in a litigation atmosphere?
Litigation in the sense that it initiated the DMV's civil proceedings against Mr. Brown for his license privileges, yes.
Okay, I understand. In other words, that at least administratively, this is, quote, litigation for purposes of the privilege, right?
Yes.
Okay.
On the other end of the trial court's consideration under the evidence code 1040 balancing test, at the trial court level, the DMV introduced evidence that the reporting process is within the public's interest in maintaining open channels of communication between the public and the DMV regarding unsafe drivers that could be that they could observe in its communities and in its cities. That same evidence also introduced to the court clarified that, yes, there was a vetting process for the DMV to be screening these reports. Further, the keeping of the identities of these reporters as confidential serves that overall public interest in encouraging use of the reporting process. The trial court found respondents' arguments persuasive. And the trial court wisely recognized that disclosure of the identities of these individuals reporting unsafe drivers would deter many, if not most, of these reports, and that this has a profound chilling effect that would result in severe ramifications. Fatal car accidents happen every day. Trial courts, appellate courts deal with the harms and the results of these every day. The DMV relies on the members of its communities to be its eyes and ears in alerting the presence of potential unsafe drivers. Second, as to why the trial court's judgment of denial should be affirmed, appellant received all due process at both hearings. The goal of the safety hearing officer in the reexamination hearing is to determine whether appellant should be made to take, in this case, another driver's test. As to how that process was initiated, again, the report was submitted by his reporter that was reviewed here by a safety hearing officer. These reports are citizens' complaints. In contrast to the cases that appellant cites, these individuals are not criminal informants. Their identities are known to DMV, but they are not DMV's agents. They're not DMV's witnesses.
Well, they can be anybody.
Certainly. But those reporters are not appearing at the DMV hearings to give testimony, to have the substance of whatever they reported to the DMV used as weight in favor of DMV's action. Quite the contrary. That's completely absent, and that is how the process is designed. The process is designed so that the only evidence in terms of indicating that driver's medical condition comes from that person's own physician.
I understand. This was a confusing case because the doctor said something that the DMV, the first officer, found it persuasive and the second didn't. So this was just a glitch in the process, it seems to me.
Yes, and we would agree, Your Honor, and we would say that, in fact, this is an example of how the process is designed to correct itself. The fact that appellant received timely notice of the first hearing officer's decision. He was able to timely seek a second hearing, and he prevailed. The process is working as it's intended to. Thus, even assuming appellant had asserted a due process claim at the trial court level, the DMV had already given back his license at that point. The trial court could not have given additional relief on a due process claim that the DMV had not already provided. In other words, that is to say, the remedy there would have been to restore his license. It would not have been to disclose the identity of the reporter. I did want to add very quickly in closing, the trial court's recognition of the chilling effect is correct, and it is profound. Most recent U.S. Census reports indicate that 90% of households own a vehicle. In California, in the past decade, more than 40,000 people have died on California's roads. If someone sees a drunk driver, they need to be able to report it. But if they have concerns that whatever they say is going to result in them being sued, they will not report it. People won't say anything, and then people will die. Thank you.
Thank you. Mr. Brown, you have 3 minutes and 49 seconds left.
Okay, I'll race through. Try not to talk so fast. All right, so for public disclosure, I don't like to talk about my health, but high blood pressure. Unfortunately, I don't think I have high blood pressure. The doctor, when I took my physical or for that clearance, thought I did. Many Americans have high blood pressure, and they're on the roads driving every day. That's the first thing. Second thing, 40,000 people have died in California, the most populous state in the nation. I agree with you, ma'am. I have a perfect driving record for over 18 years. That's the second thing. Unsafe driving. Who saw me driving unsafe in the state of California or any of these states here in America? No one. So the question is, why would someone 2 straight years within 15 months know the system so well, the administrative DMV system so well, that he can turn it to where it doesn't benefit the good, it benefits those who have legal manipulation skills? That's someone who is either a lawyer, a paralegal, or someone who works within DMV, someone who has insider knowledge. So when the Honorable Judge Robbie said, there's a glitch in the system, yes, there is a glitch. Because what if I was to see you driving and then get mad at you and then call DMV and say, well, Judge Earl wasn't driving correctly, and then I can get away with it? Well, I don't think DMV is going to be having you go see your doctor, Your Honor, with respect. They're just not going to do that. They're not. So that's why I was asking for historical precedents. If I could afford a lawyer to articulate this for me, I would. But as you know, I couldn't afford a lawyer for the other cases. The doctor filled out the form incorrectly. Yes, she's highly educated. She's a doctor, I think, with 30 or 40 years of experience. But people make mistakes. The two different hearing officers, one saw it one way, one saw it another way. That's the process. But the process for DMV is working for DMV. It's not working for me. It's not working for the taxpayer. We shouldn't be here doing this. If anyone can make a complaint against you in a secret fashion and get away with it, I think they call it swatting in other cases. But in this case, this person knew they could get away with it. But this is a repeated attack. They did it in June of 24. They did it again in October of 25. And I know why that person did it like that. I know why.
But the October of 25 is not before us, right? I mean,
You're
just dealing with the
right.
Okay.
So by the legal law, you're saying, well, Richard, you filed your appeal, so you can only talk about the June of 24. So when I made in my opening about what prevents this from happening in the future, you said, well, it hasn't happened to you, Richard. Oh, yes, it has. It happened in October 25, even though that case is not in for you. But if you do an investigation of the complainant, you'll see it's the same person from June of 24 to October 25 saying the same thing, and I had to be cleared again in 25. With that being said, I'm so grateful that you took time to listen to me today. Unfortunately, in our country, we have a rich history of discrimination. And unfortunately, not all citizens are good citizens in this country. And even though I was going to die for this country, and I still will, sometimes people do things wrongly because they think they can get away with it, and no one has the courage to stand up and fight for his or her convictions. I have that courage. Thank you very much, Your Honors.
Mr. Brown. Thank you, counsel. We will take the matter under submission and issue a written opinion. We'll take a brief recess to reconstitute our panel.